Welcome to our third lecture covering Module 3. This lecture is mainly material that we have covered in previous sessions in Modules 1 and 2. So I'm not going to say a lot about this. Certainly I would encourage you to look it over to refresh yourself. And so I'm going to focus on what I think are the new call-outs and not go over all of the material, especially the parts that have already been covered. So we're going to talk about theories of employment discrimination as well as the EEOC charge process and what happens in court after the EEOC charge process. So let's consider the four types of employment discrimination that we're going to focus on. We've already talked a lot about disparate treatment and disparate impact, but here's a reminder about what those mean. Then we have a third topic, which is failure to reasonably accommodate. Those relate to religious and disability discrimination situations. I'm really not going to talk about those today because they're very complex matters, and we're going to talk about those in two subsequent units. And then our fourth category is retaliation. I've touched on this a little bit, but basically this is punishing somebody for exercising his or her legal right to participate in the EEO process. So here are some call-outs generally that are going to help the employer protect itself against all of these types of claims. The first, of course, is don't discriminate. Don't make employment decisions based upon what you perceive as the characteristics of a particular class of employees. Undergirding this is the idea of being fair. There is no legal requirement that we be fair. After all, we are employed at will. But when you are fair, you're much less likely to discriminate, and if you get in front of the jury, it's going to be much easier to defend what you've done. Another thing to keep in mind is that most cases of discrimination, there isn't a smoking gun. It's not obvious for certain that discrimination actually occurred. In fact, in most cases, the person who's discriminating isn't even aware that that is what's going on in the situation. So you have to, if you're the manager, and our supervisor, you need to look at the situation more critically and say, what's going on? Well, how have you treated other people the same way? Well, why do you have this rule? Does this rule make business sense? And so you can't just say, okay, well, you didn't say the reason was the person's race, so it must be legally okay. When you're dealing with accommodations, flexibility is the key point. Now, I say up here, treat people fairly and treat all situations alike. But there definitely is a tension here, because we aren't going to treat somebody who wants the day off to watch a football game the same as someone who wants the day off to attend a religious service, or who needs the time off because of some medical issues. So you have to consider the totality of the situations. Certain situations require a level of flexibility under the law, and so you kind of need to approach those issues in a different way. Then, of course, when you have an employee who's filed a charge of discrimination, you have to be especially careful about how you proceed. A good rule of thumb is before you take any kind of disciplinary action against somebody who's filed a charge of discrimination last year or so would be to talk with somebody in the legal department. And so hopefully when you're advising your clients about that, remind them to keep you and the attorney abreast of any information about that. So again, we're going to look at the disparate treatment situation, and we have some action that happens that is discriminatory, maybe a subtle form of discrimination that people are not aware of. The only defense to this, if it really is true that there's a discriminatory action happening here, is if you have a BFOQ, and those are very rare. This is a very unusual circumstance where you'd actually be able to have a BFOQ. Maybe if you are working in retail and you want to restrict the people who can go into the fitting room to people of the same gender, you might make the argument that the person needs to be the same gender. I'll give you an example of a job that you would think only women can perform. When I had a client who was a retailer, a task that sales associates in the lingerie department would perform would be a breast fitter. not breastfeeder, bra fitter, sorry. And so what would typically happen is the bra fitter would go into the dressing room with the woman, and the woman would remove her top. Typically she would be fitted with a bra on, but not in every case. And so the a bra fitter would take a measurement of the fullest part of her breast and then immediately under her breast, and give a recommendation as to what size, what cup size, as well as what band size this woman would best be fitted with. And this is a good marketing strategy because a woman who feels confident about the bra size that she got to wear is more likely to buy a bra and more likely to feel comfortable in the bra, and therefore more likely to return and get additional bras. So usually what the bra fitter will do after this point, after making the measurements, is get some bras while the customer may be waiting in the room. Well, this particular store had several individuals who were anatomically male who would come into the store and request a bra fitting. These were not individuals who had breasts, nor did they, they had not had surgical changes to their body, nor did they come with something that they wanted, like a mastectomy filler that might be used. It appeared to the bra fitters that these men were doing it for a sexual titillation of being able to take off their shirt and being measured by a woman, putting a band across their chest. Anyway, the perception in the store was that these were men who were seeking a sexual titillation, or at least they were seeking intentionally to make these women uncomfortable. And keep in mind, these fittings are happening where the salesperson is alone in the dressing room with this individual who appears to be male and who is significantly larger. And so many of the lingerie and traditionally employees in this department store, in the lingerie department, were women. And so many of the women would tell the manager, I'm unwilling to do a bra fitting for somebody who appears to not have, to be of masculine anatomy. And in this particular state, this was before the Title VII U.S. Supreme Court decision, but in this particular state, the state law protected transgender individuals and also gender expression and gender identity as protected categories. And so there really wasn't an option of turning these individuals away, even if perhaps these individuals' motivations were not necessarily, who knows what the person's motivation was under those circumstances. Anyway, so what the department store chose to do was to have the men in the management positions in the store trained to be bra fitters. So the men went through bra fitting training, but the only people they ever bra fit for were these individuals who the female associates were uncomfortable fitting because the female associates were concerned about their personal safety. And so in this particular store, we had several, and of course, these customers could show up at any time. And so what the female associate would do when a person presented, when that person presented as saying, I want a bra fitting, is the female associate would say, great, let me call a certified bra fitter to assist you. And so there had to be a manager on duty at that time who could pop in and do the bra fitting. And so all of the management staff, including all the men, were trained for that role because there was always a manager on staff in the store. So you might think that the task of bra fitting was an exclusively female job, but you can see in that context that it is not necessarily an exclusively a male-fitting job. But I would argue, for example, a mammogramist would probably be a job that you could make a pretty good argument that women, that there would be a BFOQ limiting that career path to women would make sense, because the vast majority of people who get mammograms, which is basically an x-ray of the breast material, and when this happens, the woman is unclothed. In addition, the mammogramist needs to manipulate the breast so that it's between two plates. So there's a very significant amount of touching and moving around of the breast material. So you could easily see how many women would be very uncomfortable with a man performing that role. So I could argue that one might be a BFOQ of only females. But again, really aside from jobs that involve using a particular body part that's unique to that gender, or that involves personal modesty issues, you're really not going to have many female, male type jobs. You can't have a BFOQ for national origin, or, well, you can't have it for race. And there's relatively few for religion. Of course, there's the ministerial exception, but that's different than the BFOQ. Reverse discrimination is a protected thing. People cannot be discriminated against because they're African American or because they're Caucasian. People can't be discriminated against because they're a woman or because they're a male. People can't be discriminated against because they're Jewish or because they're Christian. In other words, both the less quote-unquote favored category and the more quote-unquote favored category are protected. Now, just because women and men and Christians are protected from discrimination doesn't mean that it's as easy to prove discrimination in those situations than it is to prove it when the less quote-unquote favored group is discriminated against. It's relatively hard to prove discrimination as a male or as a Caucasian or as a Christian compared to other groups. Pretext. This is a definition. We talked about this before, but I don't think I had it in red, so you may want to add this to your Quizlet. A pretext, again, is when the employer's stated reason for the employment decision is not the real one. So in this case, the plaintiff presents evidence that what the employer said is not the genuine reason. We talked about mixed motives before. You may recall the Desert Palace versus Costa case. That's one good one to review there. Pattern or practice is when there's systematic discrimination. Again, you're going to be looking at statistics a lot. The Hazelwood case is a good example of that. We'll talk at great length about harassment. We have a module on that topic, so I'm not going to spend time here. One thing I will say about it, though, is that harassment we think of as being related to sex, and certainly that's the most frequent category, but really any protected characteristic can be subject to harassment. You have national origin harassment, race harassment, gender harassment, age harassment, disability harassment. So, and here's a reminder about the prima facie case situation. Again, this is, if we think about, the ping pong ball, the ball starts in the plaintiff's case. The plaintiff's first job is to come up with a prima facie case. Once he comes up with it, then the ball falls into the defendant's side to present his non-discriminatory reason for the action. And then it goes back to the plaintiff to show that reason, to rebut whatever that reason is. So the prima facie case is typically the plaintiff's member is a member of the protected class. He or she applied for the job or already had the job. He or she was qualified for the job but was either denied the opportunity or removed from the opportunity. Keep in mind the most common story here is termination. And then the defendant either hired somebody of a different class or continued looking for somebody in that class after that person was denied the position. Covered this one. Again, you don't have to use that prima facie case, that bouncing ball method, if you have direct evidence. Now, obviously, the defendant still has the opportunity to rebut that. Many times, the direct evidence is a he said, she said situation. So Bob feels that he was discriminated against by Mary, and he says, well, when Mary dismissed me, she said she was dismissing me because I'm a man. Well, Mary says, no, I didn't say anything like that. Bob's making that up. And so obviously the fact that Bob presented that evidence does not conclusively prove that that evidence is true. And so Mary would be entitled to present evidence that either refutes that, her testimony, she never said that, or that puts whatever that evidence is in context. For example, maybe Mary meant by that maybe she says, no, I didn't say I'm firing you because you're a man. Maybe she said, I'm firing you because you're a bad man, meaning you're bad at your job. I mean, it had nothing to do with your gender. I was just using the term generally to refer to a human being or something along those lines. Circumstantial evidence, again, the plaintiff can rely upon that too, and especially comparative evidence. Both sides, both plaintiffs and defendants, routinely use that. And comparative evidence is some of the most powerful evidence in these cases. We talked about the cat's paw theory. Again, I think I had it in red in a previous slide, but if you don't have it in your Quizlet, I encourage you to add that. That's when one worker who has a bias reports or provides evidence in an investigation that ultimately leads to another worker getting fired. The person making the decision has no bias, but he or she relied upon that evidence from the person who wants to discriminate. And so that's how the cat's paw work. So you have to be careful how you evaluate the sources of information. And if you are the person who is approving or making the decision, you need to make sure you have all of the evidence, and you need to understand where people are coming from in terms of their motivation. And ultimately, this comes back down to you need to train the supervisors, not just the managers, because supervisors can have these prejudices and they can indirectly or directly, I guess, impact the managers, even though the managers are not aware of the pre-existing prejudice. Let's talk about disparate impact. This is a less common theory. Certainly disparate treatment is the vast majority of discrimination cases, but you certainly can have a disparate impact case. So here we have a neutral requirement of the employer. It doesn't say anything about race or sex or religion or anything like that. And it's applied consistently across the group of employees or applicants. But this neutral policy has an unequal effect upon people based upon the protected class. If the plaintiff can prove those two things, then the defendant needs to come back and show that it is job-related and consistent with business necessity. So imagine that we had a policy that you had to be a certain height to be a firefighter. And there were lots of statistics available that show that somebody who was under 5 foot could not safely do many of the tasks that are required in a burning building. Well, then that standard would obviously exclude more women than men, because women are usually shorter than men. It would probably also exclude more Latin American or Hispanic individuals than, say, African American or Caucasian individuals, because people from Latin America typically are of less stature. But if you can show that it is job-related and consistent with business necessity, it's okay that it has a disparate impact upon a particular protected category. The standard for age cases is a little bit less demanding on the employer than job-related and consistent with business necessity. It's a reasonable factor other than age. RFOA is the usual way that people talk about it. This is an easier standard to meet. And the idea here is that in age cases, Unlike the other categories, which are a fairly static thing. I mean, if you're born African American, you're going to be African American all of your life. If you're born a woman, you're going to be a woman all of your life. Probably if you're born of a particular religion, you're going to be that religion all of your life, probably. But age inherently changes. And so, and it affects everybody ultimately. And we all know that as we age, we are going to see a diminishment in some of our skills. We're going to be less strong. We're going to be less quick. We're going to, as we get significantly older, less mentally sharp in some cases. And so these are issues that are going to happen to us all, although at varying points in our lives, depending upon the circumstances. And so to say that an 80-year-old isn't as spry as a 30-year-old is hardly a surprising or unusual statement. So if you were to say have a requirement that in this physical work that you have to be able to lift 50 pounds, it wouldn't at all be surprising that the 80-year-old applicant wouldn't be able to do it as well as the 30-year-old applicant. And so you could say under those circumstances that the plaintiff, the 80-year-old plaintiff who isn't hired, would be easily able to prove that that requirement that the worker be able to lift 50 pounds is a neutral requirement, but that it's going to adversely affect older applicants. It might be difficult to show that's a business necessity in each case. So the decision was to make it a somewhat less challenging requirement so that it's a little bit easier for employers to have those standards. Otherwise, those standards might be difficult to enforce with the older workforce. Now, if the defendant is able to show that there is that job-related reason for the policy and that the policy is consistent with business necessity, the plaintiff still has an opportunity to win. So just like we did the ping pong ball with disparate treatment, we had the prima facie case, the defendant's response, and then the plaintiff's rebuttal. We have that same back and forth with disparate treatment. We have the prima facie case, we have the business necessity argument, and then we have the opportunity for the plaintiff to show that there is a feasible, less discriminatory practice that could have been adapted by the defendant but wasn't adopted by the defendant. For example, if that 50-pound box, if in this particular position, workers never have to carry a 50-pound box by themselves. The most that really any worker ever needs to carry is a 30-pound box. Well, you could argue, well, why don't you just instead have the applicants carry a 30-pound box? Now, again, this final step is not available in the age cases where we're using the standard of reasonable factor other than age. But all the other categories of discrimination, there is that rebuttal opportunity for the plaintiff. Here are some examples of the types of tests that are very prone to disparate impact theories. Written employment tests can be difficult for individuals who have less education, and some members of our culture, because of economic reasons, are less likely to be much likely to have a good, solid education. So this might negatively impact, say, African Americans or Hispanic individuals. We already discussed height and weight categories. Language categories can affect people based upon a national origin background. Physical strength categories can be difficult for women in some cases. Military service can be somewhat more difficult for women, not that women don't serve, but they're less likely to serve. So these are some examples. We'll talk more about the arrest and conviction aspect when we talk purely about race discrimination. We've already talked about the educational attainment issue. So now we're ready for retaliation, our fourth theory. We've talked about disparate treatment, disparate impact, and the failure to reasonably accommodate. Now we'll talk about retaliation. So this is when, instead of looking at the characteristic, we're looking at what this particular employee has done, his or her activity. And there's two categories of protected activity under Title VII. The first is participation. And here you're involved in the enforcement of an anti-discrimination law. You may have been interviewed, you may have been subpoenaed to testify, and you testified in a case. And under those circumstances, your employer may not like how you testified. You were under oath, you had no choice. Also, opposition means when you are speaking out against discrimination. Perhaps you're the person who reported the incident, either within your company or to a governmental agency. Both of these are protected categories, and they both can be subject to retaliation. So again, we see this prima facie case again. The plaintiff engaged in protected activity. Again, one of these two activities here, or both. Then the plaintiff suffered a materially adverse employment action, and that there's some link between the protected activity and materially adverse action. Now I'm going to tell you something. I don't want you to get too cynical here, because this is not always the case by any means. But it certainly happens that employees who recognize that they may be, that their jobs may be in jeopardy, either because of performance issues or because they think they may be part of a layoff, sometimes decide to engage in a bit of self-help. And they will complain of some type of discrimination and or file a charge of discrimination in the hopes that that will make the employer less likely to dismiss them, because then they can say, well, I filed my charge on Monday and I was fired on Tuesday. Well, that certainly seems suspicious. Of course, when you consider that the employee knew that his work performance had not met the standards that the employer expected, and that his performance improvement plan was about to expire, his decision to file a charge sounds a little bit convenient, perhaps. But in some cases, there's merit to the employee's claims. But as an employer, it's a good idea to be aware that sometimes employees do respond by filing a charge under these circumstances as a way to help, or they're thinking to provide themselves with some protection. If the employee is able to make this prima facie case, and again, it's more than just timing, though if there is really convenient timing where the protected activity happens, then shortly after there's that negative event, then very likely that causal link will occur. So if the employee makes the prima facie case, then the defendant can respond with, well, no, that's not why we fired this person. This person had a sales goal. He had been told if he didn't meet the sales goal, he would be dismissed. So therefore, that's why he was fired. Obviously, then the plaintiff gets the opportunity, as we talked before about the ping pong ball. Plaintiff makes prima facie case. Defendant gets to present non-discriminatory reason. Plaintiff gets to rebuttal it. Employers are also prohibited from retaliating against somebody close to the employee, such as a family member or a close friend. Hey, I'm going to fire you for, if you file a charge, I'm going to fire you. Or maybe I'm going to fire your best friend or your spouse, that type of thing. That's also prohibited. And so the friend or family member is protected even if he or she did not engage in protected activity. So now we are done with the types of discrimination, and we're going to talk about the EEOC charge process. We have talked about this to a significant degree, so I'm not going to spend a lot of time on this. Let's talk about what that process looks like. And as a paralegal, you will be very involved, HR paralegal, you'll be very involved in responding to charges of discrimination. When I worked in a law firm and also in a corporation in the HR area, paralegals were probably the principal people who dealt with the EEOC in terms of writing position statements and things along those lines. So it's a very common role to have. It is probably the single biggest part of the role of most employment law paralegals. So it's certainly a fertile topic for us to talk about. The EEOC is busy. It gets lots of charges of discrimination. It's not an especially aggressive agency. The Department of Labor, Wage and Hour Administration and the National Labor Relations Board are both much more aggressive agencies than the EEOC. It handles Title VII, the Age Discrimination and Employment Act, the Americans with Disabilities Act. It does not handle, it also does the Equal Pay Act. It does not handle Section 1981 claims. It does not handle FMLA, for example. So it's not every single topic that we're going to talk about, but most of the areas in this course are issues that DOC will be handling. So in this case, Mary wants to bring a racial discrimination claim against her employer under Section 1981. Because the EEOC does not administer that law, Mary doesn't have to go to the EEOC to file her charge. And she probably will want to, because if she's filing a Section 1981 claim, she's alleging either race discrimination or national origin discrimination. So why not also advance a Title VII claim? I guess the only reason not to is if she missed her statutory period of 300 days in Texas for a race or national origin claim. The Section 1981 claim is 4 years long, so she has a bit more time under that law. But if she hasn't missed the statutory period for Title VII, her attorney will probably advise her to go ahead and file a Title VII claim anyway, but she doesn't have to. Now, for many of the laws, especially Title VII, Mary would have to file with the EEOC before she can file her lawsuit. We call that exhaustion of administrative remedies. It's not an idea limited to employment law, but certainly it is a major factor in employment law. So the EEOC has to complete the entire review of the charge before Mary would be able to file a charge of discrimination. If there is no 706 agency, the number of days are 180, but in most states there is a 706 or an FEP agency, those are the same things, and so the date is going to be 300 days. Texas does have a 706 agency, so we have the 300 days. So these agencies are called, or they're operating under the authority of the state legislation pertaining to discrimination, and they have what's called a work sharing agreement with the EEOC. So they may handle the charge or they may refer it to the EEOC. The EEOC has a Dallas office, as well as other offices in Houston and other cities. The Texas Workforce Commission Civil Rights Commission, weirdly the commission appears twice in its name. I can't defend that. I'm not sure what they were thinking. That is our Texas's 706 agency. It has only one office in Austin. As a result, in North Texas, I would say virtually all of our charges are handled by the EEOC. I have never seen a Dallas area charge handled by the Texas Workforce Commission. Now, when I was at JCPenney and at Baker Botts, I handled charges all over the state of Texas, and so I did deal with the Workforce Commission. I would say if the EEOC is not very aggressive, the Texas Workforce Commission is perhaps even less aggressive than the EEOC. So it's not a very intimidating agency in my experience. So after the EEOC gets the charge from the charging party, it sends a notice to the employer saying, hey, a charge has been filed against you. It gives the employer the information about the charge. And oftentimes at this time it will ask the employer if the employer is interested in trying to mediate the claim or to resolve the claim before an investigation begins. And here's a definition of what a mediator does. The EEOC will do this mediation free of charge. You kind of get what you pay for, though, in this situation. Maybe they aren't the highest quality mediators. And in my experience, I've never settled a case through an EEOC mediation. So I haven't found it overly successful. The concept is a good one, but maybe the execution might not be the best in every case. About 15% of cases do go to mediation. So let's consider this case. Bob has filed a discrimination claim with the EEOC. So again, within those 10 days, the EEOC sends a notice to Bob's employer. Again, they can both decide to go to mediation or not. Both Bob and the employer have to agree. If either one says they're not interested, then the investigation will start. If the mediation process works and an agreement is reached, obviously it has to be voluntary. Both Bob and his employer have to agree to it. And if they both agree to it and sign on the dotted line, then it's a binding agreement between the parties. Obviously, if it doesn't work out, then the investigation goes forward. So the investigator gathers information about the charge. And by the way, being an EEOC investigator is another career path to consider. You would likely be working in the downtown Dallas office, but there may be opportunities to work from home, or certainly in that career path, many times you would be going to facilities to review documents and interview witnesses. So that could be a rewarding career path for somebody with an interest in employment law, and so something to consider. So once the EO investigator hears from all the evidence that the charging party wants to present and all the evidence that the respondent employer wants to present, then it makes a finding of either probable cause or no probable cause. Now, the investigator does not have carte blanche in this area. He or she makes a recommendation, and it has to be approved, I believe, by the regional attorney, or at least somebody in that staff. I was surprised by this statistic. I thought it was much higher than this. According to at least one report, the no probable cause findings is in about 64% of the cases. In my experience, it's more like 95+%. I guess I've just always had good clients who don't discriminate very often. So I apologize. I think I said in an earlier lecture that it was like 95%, but clearly I was mistaken, or at least this other data point suggests I was mistaken. So this is what reasonable cause means. This means that the EEOC has found that Title VII was likely violated. And you can see it says reasonable cause. They aren't saying we're 100% sure, but they're saying it's more likely than not. In this case, typically we go through a conciliation process. This is very much like mediation. But now, of course, the EEOC is a little bit more taking the charging parties' claims a little bit more seriously. And so it's a little bit more of an intimidating process now, because the employer is realizing that probably if he doesn't settle at this point, there's going to be a lawsuit. The no probable cause finding is the more usual finding. And here the EEOC finds that there's no reasonable basis to believe that Title VII was violated. Now, you may think when you get this finding, if you are the employee, that you think to yourself, oh gosh, if I couldn't persuade the EEOC, there's no way I'm going to be able to persuade the jurors. That's not true at all. As I say, my experience is that the vast majority of the time the EEOC finds no probable cause. But my clients have not been that successful in front of juries. So just because a particular plaintiff wasn't able to persuade the EEOC doesn't mean that the jury cannot be persuaded. EEOC investigators are oftentimes a cynical group. They've seen a lot, and they are perhaps not as, you might think to yourself that they would be very pro-employee, but you know, they kind of bear some battle scars, I guess, from having heard enough stories that didn't pan out to be a little bit suspicious, maybe overly suspicious in some cases. So if there's a no probable cause finding, we know that the EEOC is going to dismiss the charge and issue that right to sue letter, which gives the charging party 90 days to file its lawsuit. Whether the EEOC issues the reasonable cause or the no reasonable cause finding, the charging party can always file a lawsuit. The charging party will always get the right to sue letter unless the EEOC decides to sue on behalf of the particular worker. Okay, here's a definition of conciliation: the act of attempting to reach agreement on a claim through discussion without resort to litigation. And of course, the right to sue letter. The charging party has 90 days. You do need to know this date. You also, by the way, need to know the 300 days limit. So be sure that would be a good one to add to your Quizlet. You know, how, and also obviously this one, 706 and the FEP. You'd want to for sure add, you know, the you might have as your definition the number of days that a Texas charging party has to file its claim, for example. So the EEOC has investigated Bob's complaint and has sent him a no probable cause finding and the right to sue letter. So Bob has 90 days after he receives the letter. So it's not from the postmark date, from the date of mailing, it's the date of receipt. So let's assume a no probable cause finding, a right to sue letter issued, and Bob now has 90 days to file his lawsuit. The reason that he's given 90 days is to give him a bit of time to find an attorney. He certainly could have found an attorney earlier on, and that would have probably been a good idea for him. If Bob had found an attorney earlier on who was going to take his case, most likely the attorney would have requested that a right to sue letter issue. The EEOC is not required to issue a right to sue letter whenever the plaintiff wants one, but oftentimes it will. Like many governmental agencies, it is overworked and understaffed. And so if it sees that a charging party has representation and is interested in going to court, there's really no reason to continue the process. And so very often, if it's not a case that the EEOC has identified as one that it plans to litigate on its own, it will go ahead and issue the right to sue letter, even if it hasn't made a finding. And of course, that then frees up Bob to begin his litigation. The EEOC can easily handle a file for months, and I've even seen some that have lasted for well over a year before the right to sue letter issues. And during that time, Bob may be between jobs, and so he may need to get this matter resolved sooner so that he can get the money that he's entitled to. So let's consider judicial review. So Bob has gotten his right to sue letter. He is now ready to file his lawsuit. What's going to happen in his lawsuit? Well, we call this process judicial review. And of course, when you see the word judicial, you see judge in here at the beginning of the word judge. And of course, review means to look at again. Look again. So what does judicial review look like in this situation? And after all, the EEOC has already looked this over. Why do we need another look? Well, we do because governmental agencies really never get the last say. There's always an opportunity that whoever doesn't agree with that decision can take it to a court. So Bob got a no probable cause finding. He can go to court to see if maybe he'll get a better finding. But even if he had a probable cause finding, that doesn't mean that he's going to win in the trial court. Because in fact, the jurors are never going to see either the probable cause finding or the no probable cause finding. That is not shared with the jurors. Probably the judge is going to hear about it, but it shouldn't, in theory, affect the judge's opinion. And the reason why there shouldn't be any effect is that the review is called de novo. This is an important legal term that we see in lots of areas of the law, not just employment law. And that means that the trier looks at this matter completely with fresh eyes and gives no deference whatsoever to what someone else decided. Well, this is often the standard, or sometimes the standard used in appeal cases. So the trial court handles it as if the EEOC had never looked at it. The EEOC's finding has no evidentiary weight. There is no discretion extended to the EEOC or deference given to the EEOC. As I said before, usually the claimant, in this case Bob, is going to file the lawsuit, though in a small percentage of cases the EEOC does exercise its right to litigate the case. The EEOC gets to pick the best cases, obviously, and it does do a good job at picking those cases. So when it actually does decide to litigate a case, it stands a very good chance of winning. It has a very high success rate. Plaintiffs usually win about 50% of the time. So they, again, because the best cases the EEOC has taken, although there are many good cases the EEOC doesn't take part in, the claimant working by himself isn't going to do as well. And that's not because the EEOC has the best lawyers ever. I mean, they've got good lawyers, but it's more that they get the best cases. Let's talk about mandatory arbitration. We talked about this earlier. We talked about the fact that about a third of major employers use employment arbitration agreements to some extent. So it's not a rare thing that employees can have signed a mandatory arbitration contract. And typically when they've done so, they filed or they agreed to this long before there was any discrimination or bad blood between themselves and their employers. So what is a mandatory arbitration agreement? Well, it's an arbitration that the employee signs typically as a condition of employment, meaning that if the employee decides not to sign it, he's no longer going to be employed by that company. And that requires that workforce disputes be arbitrated rather than litigated. Generally, these agreements are legal in Texas. They're legal in most states. There are some limitations associated with them. For example, the mandatory arbitration agreement cannot prohibit the EEOC from the EEOC litigating the case. And of course, arbitration is usually a quicker process than the court system, and it oftentimes is a less expensive process than the court system. So those are some differences between arbitration and the court system. And so what happens usually is that the plaintiff has a mandatory arbitration agreement, gets his right to sue from the EEOC, files his lawsuit, and then the employer files a motion to compel, attaching the executed arbitration agreement to the motion to compel arbitration, and then the court dismisses the lawsuit, and then of course the former employee files an arbitration claim through the mandatory arbitration procedure, and the case proceeds at that point. So Bob worked for Mary's Aquarium. He had a mandatory arbitration procedure. He became a member of the Rastafarian religion. He feels he was fired because of his religion. He files a charge with the EEOC. The EEOC quickly files a lawsuit on his behalf. Mary's Aquarium would love to compel arbitration in this situation, but because it's not Bob suing Mary's Aquarium, but it's the EEOC, Mary can't compel arbitration in that situation. So Mary signs an employment contract with Rabbit Cosmetics, and she has a mandatory arbitration procedure in that. She's denied a promotion, so she's able to assert an adverse action. She files a charge of discrimination with the EEOC, and she can't herself file a lawsuit, but again, the EEOC can pursue the claim because, of course, the EEOC never signed any kind of mandatory arbitration provision, nor would it. There are certain record-keeping requirements that employers have to do. They have to be available to the EEOC, and every year employers have to file an EEO1 report that documents the ethnic and gender composition of its workforce, and it divides up the workforce into a variety of categories of positions. So here are some things to think about. Much of the strategies to avoid discrimination charges is just having good HR practices. If you're doing things the right way, the odds of getting a lot of discrimination charges are significantly reduced. If you're a large organization, there's nothing you can do to get rid of all of them, but you can have a relatively low number of items. And part of those processes are going to be having levels of review, having procedures in place, having checks and balances, so that one person can't bend the rules or step outside of the rules to do things serving his or her own interest. Documentation is also so important, because that person who's making the decision in several years isn't going to remember necessarily why he or she made the decision, or he or she may be gone from the organization at that time. So you want to have that paper trail showing why you did what you did, and also show when you did what you did. all of that are really, really important documents. You know, if you haven't documented it, it's like it never even happened from a legal perspective. Obviously, there's a lot of training required in getting the workforce or reducing the instances of discrimination in the workforce. Obviously, supervisors and managers need to be trained, but coworkers also need to be trained. Everyone needs to understand what the Title VII and other discrimination laws, what protections are provided by them, and to whom they apply. Also explaining how there can be liability to the employer, certainly, but there's also individual liability under these statutes in many cases. And walking through concrete examples of how in a particular workplace discriminatory actions can occur. You don't want to stay up in the clouds in theory. You want to get down into the nitty-gritty and say, this is what discrimination might look like in our factory or in our workplace. And you need to you have a culture where people know that they can safely report things and know that management takes seriously these types of concerns. So we're at the end of this module. I thank you for your attention. As always, if you have questions, please pop into my office hours. I would love to talk about these in more detail with you. Thank you so much for your attention and have a wonderful day. Take care.